Welcome to Benchmark TV, and it's great to be here to share with you some thoughts and insights into legal costs. My name is Mike Dudman and I run the Sydney office of Blackstone Legal Costing, and I'm joined today with our co-presenter Chris Grisenti, who is an associate solicitor based in our Melbourne office, and it's great to have Chris here today. We're working on a couple of things in our office today and this week in relation to security for costs, but we thought this would be a great opportunity to present to Benchmark's audience in relation to some very topical cases which we're going to be having a look at in a minute, particularly relating to the indemnity principle. But first, a little bit about you, Chris, and welcome to Sydney.
Thanks, Mike.
Perhaps you could just fill the audience in a little bit about the sort of work you've been doing in the Melbourne Blackstone office.
Sure. Really, I do a lot of work on party kind in the assessment program down in Melbourne, and also appearing at taxations. Recently, I've kind of delved into more of the solicitor-client aspect as well, and making sure that our clients are charging the right amounts to their clients, and making sure they don't overcharge.
Fantastic. So you certainly have an opportunity to see a full range of costs orders and costs that are recoverable both on the inter partes basis and on the practitioner-client basis. And one of the things we're going to be looking at today is the indemnity principle. Can you explain to the viewers exactly what that is?
Sure. The indemnity principle, or indemnity rules it's sometimes known as, basically says that on a party basis, a solicitor can't recover more from an unsuccessful litigant than what they would charge their own client. It was looked at the major decision in Shaw and Yaranova, and I've got a quote here from that case. It's from Justices Redlich and Mandy, and it says that an order for costs aims to provide the successful party with some level of indemnity for the legal costs the successful party would not have incurred. Such an order does not entitle the successful litigant to recover more than he or she has paid or is liable to pay. So it's making sure that successful litigants don't profit from any litigation.
Yes, that's a term we frequently hear, isn't it? A litigant can't go into litigation with a view to or an ability to obtain a profit out of the costs that they're charged by recovering more from the losing party. So perhaps you could explain to us the difference between what cost recovery is and how it compares to what a solicitor can charge.
Sure. So party costs are those which are reasonable as between the parties, and it's essentially what work done by the solicitor can be recovered from the other side. Generally, these are done pursuant to an order of the court, and in Victoria, for example, they're calculated pursuant to a scale. So for example, if it's a matter that runs in the Victorian Supreme Court, there's the Victorian Supreme Court scale which applies. Solicitor-client costs, they're calculated in accordance with a solicitor's cost agreement, so long as it's valid. So that's the distinction between party and solicitor-client in Victoria, in that scale costs apply for party recovery, whereas a cost agreement applies for solicitor-client. It's a little bit different in some other jurisdictions. I know in New South Wales, party recovery can be in accordance with a cost agreement and hourly rates, but there's still a distinction as to what can be recovered on a solicitor-client basis compared to party. For example, if you have a client that needs a lot of hand-holding throughout a matter, they need lots of conferences, these are things that can be recovered on a solicitor-client basis, but that doesn't mean they're reasonable on a party basis.
And you raise an interesting point there. In Victoria, costs on the solicitor-client basis, as between practitioner and client, are recoverable pursuant to a cost agreement, as they are really anywhere in Australia. But isn't it also the case that many cost agreements in Victoria are based on scale, and so solicitors will charge their clients pursuant to scale? How does that impact the cost recovery on the party basis?
Well, it really depends on what the matter is and what the cost agreement says. So some practitioners in Victoria will have costs chargeable on a solicitor-client basis pursuant to the Supreme Court scale, I should say, regardless of where the proceeding itself was, if it was a magistrate's court proceeding, for example. Otherwise, as I kind of expressed before, if there are some things that are more reasonable on a solicitor-client basis, so for example, all of those conferences, then that's where the difference is between scale on a party-party basis and scale on a solicitor-client basis.
Sure. Which sort of brings us to New South Wales, which is another case in point, where we have deregulated costs, and so costs that are recoverable on a practitioner-client basis, as with Victoria, are costs recoverable pursuant to a cost agreement and typically charged on an hourly rate basis. And those costs, when recovered inter partes, are generally recovered also on an hourly rate basis and may not necessarily be pursuant to the costs agreement, but are based on a fair and reasonable hourly rate. Would that be right?
Yeah, that would be right. So for example, if you go to a large Sydney firm, they may be charging $770 per hour, including GST for time spent by a partner. If it goes through the cost assessment process, they may only be able to recover $550 per hour. So that's where the shortfall lies.
So that raises an interesting question, doesn't it? How can party-party costs exceed those recoverable on a practitioner-client basis, at least in the quantification of those costs?
It really depends. There are two great examples, one of which is part of the case study we're going to be looking at today. But the first example is, let's look at the Victorian Supreme Court scale. When you're reviewing documents, so for example, taxation documents, it's reviewed per page. And this year it's $7.90 per page. So let's kind of scale that back. If a solicitor is reviewing, say, 50 pages of documents and they spend half an hour reviewing it, let's say there's an hourly rate of $400 per hour. That allows for $200 for the solicitor to review it on a solicitor-client basis. On scale, 50 pages at $7.90 per page is close to $400. So that shows that sometimes scale can be higher than what the solicitor would ordinarily charge, and that's where you can get discrepancies between party-party and solicitor-client, where party-party is higher.
That's an interesting example, and so overall, if practitioner clients' costs assessed on that basis are lower than costs assessed on the inter partes basis, that leads to a breach of the indemnity principle, doesn't it? It
does, yes. And so in Victoria, if there would be a breach of the indemnity principle following the conclusion of a taxation, the solicitor must tell the court so that the taxed costs are lowered to what they actually would be charged.
I see.
So there's no profit.
And getting back to the example you gave, in that instance, one particular item may be considered to breach, if you like, the costs recovered or charged to the client for that scanning attendance. But that's not really how the courts view it, is it?
No, it's a global basis. So the totality of the solicitor-client costs and the totality of the party-party costs. So both professional fees and disbursements. We're
going to be looking at a couple of cases with Chris which really explore the indemnity principle, don't they? The cases of Kilkenny Walsh Proprietary Limited and Strasburger Enterprises, and the case of Peter Murick and Roland von Marburg. Let's firstly look at the Kilkenny Walsh case, a 2014 case which has led into the Murick, more recent case of Murick. What were the principles established in Kilkenny Walsh?
Kilkenny Walsh, it was a proceeding run in the Supreme Court of Victoria. It was a dispute between the two parties. It's a little bit close to my heart. I worked on it personally as a paralegal back in the day. And it was leading up to trial, and just before trial, the applicant accepted an offer of compromise of $1 million. Following the acceptance, a bill was then prepared, and the bill totaled $2.7 million. The parties tried to negotiate, got nowhere, so a summons for taxation was filed in the Cost Court in Victoria.
Interesting, and automatically as a cost lawyer I hear that those numbers, and I think, well, proportionality is a bit of an issue in this, but how did the court deal with the costs?
Prior to dealing with the costs, the respondent actually sought production of certain documents from the applicant to establish whether there had been a breach of the indemnity principle. The documents that they asked for were tax invoices from the solicitor to the client, all the cost agreements between the solicitor and the client, any third-party funding, whether there are any documents relating to that, and all of counsel's fee slips and back sheets.
in short, anything to do with costs, they would like to see the documents relating to that. Interesting case, Kilkenny Walsh, heard before Judicial Registrar Goulet. And my understanding is that production of each of the documents sought was opposed. Is that the case? And if so, perhaps dealing firstly with the retainer agreement, how is that dealt with?
You're correct. The applicant did oppose production of all of the documents based on the fact that they submitted it was a fishing expedition by the respondent. So the matter was heard before Judicial Registrar Goulet and it went to a preliminary hearing. In relation to the retainer agreements, it was found that they should be produced to the respondent because they dealt with the extent that the applicant was liable to their solicitors.
So you've got to establish that liability for costs prior to enabling you to recover them from the other side. And the third-party funding agreement, that's an interesting request for production. It doesn't often arise, of course, but in this matter, how did Judicial Registrar Goulet determine that?
She ordered that they didn't need to be produced, that it was a fishing expedition and that they actually didn't have any bearing on whether the applicant was liable for any invoices or disbursements.
And turning to disbursements, certainly my experience in New South Wales is that practitioners are quite happy to pass over copies of disbursements to another party who seeks them in the cost assessment process. How was the issue dealt with by the court?
Again, the Judicial Registrar found that these were documents that ought to be produced on the basis that they would have to be produced out of taxation in any event, and so providing them prior to a taxation just established that this is what the liability was and it showed the extent of work done by counsel or experts.
Right. Whereas tax invoices are a slightly different kettle of fish, aren't they? One would assume that the total charged in relation to professional fees as appear in tax invoices would beyond doubt establish that their liability arises and perhaps the limit of that liability. But how did the court deal with those tax invoices?
The court ordered that they didn't need to be produced on the basis that there's no breach of the indemnity principle until costs have been taxed. And so trying to look at these documents prior to costs being quantified is a fishing expedition because they have no bearing.
So the documents largely were directed to be produced, essentially with the exception of the tax invoices. How is that relevant to the indemnity principle?
Well, this is where it leads directly into the second case we're going to look at, but the production of cost agreements shows that there is a retainer and there is a liability for costs. May as well start looking at von Marburg now.
Tell me about the background to that matter. It seems like an interesting case.
Yes, so the applicant in the cost court proceeding was the second defendant in the substantive proceeding, which was again a Supreme Court proceeding. And throughout this proceeding, there were interlocutory orders made by the court whereby the plaintiff, who becomes a respondent, had to pay Muruk's fees of the interlocutory applications.
So if the proceeding was still on foot, how was Muruk able to have these costs assessed?
Ordinarily, he wouldn't. There is an order there's a rule in the Supreme Court rules that says the costs of an interlocutory application aren't recoverable until the conclusion of the proceeding itself. However, there's an exception to the rule, as there normally is in legal issues, and that's where the court orders that the costs be paid forthwith. Means they're to be paid immediately, and that's what happened in this case.
Okay. That sort of gives us rise to an interesting question, and that is really how does this decision impact work undertaken on a pro bono basis?
So the respondent to the cost court proceeding raised a preliminary point which essentially was whether the applicant had any liability to pay legal fees to his solicitor. This was on the basis that there had been correspondence between the parties whereby the applicant's solicitor said that they were acting on a pro bono basis.
And I suppose this is also relevant, therefore, to cost agreements on the conditional basis. Let's explore that a little bit.
Sure. Conditional cost agreements legislated under the Legal Profession Uniform Rules, Uniform Law, and it says that basically work is only charged for if there's a successful outcome. And a successful outcome must be defined in the costs agreement. And so if there is a conditional cost agreement and one of the conditions isn't met for a successful outcome, then there's no liability to pay. So getting back to the case of von Marburg, the respondent sought provision of all cost agreements as between solicitor and client and counsel and solicitor to determine whether there was a liability for legal fees to be paid. So after this request had been made, the applicant, again, as they tend to do, objected to the provision of these documents. The matter had been set down for a preliminary hearing as to whether they should be produced, but prior to this, the applicant acquiesced and provided those documents to the respondent solicitor.
Okay. And what happened next?
This matter was referred to Associate Justice Wood in the Cost Court to determine whether there was liability to pay solicitor-client fees. And the Associate Justice looked at it in quite great detail, but split it up between professional fees, as between Muric and his solicitors, and then between Muric's liability to pay for counsel's fees.
Okay. So that seems like an extraordinary step to take, to refer it to an Associate Justice for a decision like this, and I suppose that gives weight to the decision that was made. And what was the decision?
Well, the applicant argued that their client was liable for costs, and I'll read you a portion of what they referred to in the cost agreement. Was that we have agreed that we will not charge you for the work except where specified below, and that the matters we will invoice you for are expenses and disbursements in connection with the work. That seems like it says quite clearly, we're not going to charge you for anything. However, what the applicant argued was that as the agreement was silent as to price, a reasonable price similar to what we discussed earlier in New South Wales for work done on a party-party basis ought to apply. What the applicant also argued was that in the agreement it states, where you are the beneficiary of such an order for costs, we may give you an invoice for our charges, including our professional fees, to an amount no greater than the amount recovered from another party. So it seems like it contradicts the earlier statement that they wouldn't charge fees, but if there's a costs order, we'll provide you an invoice for what's recovered.
What is recovered? So that's the key here, isn't it?
It is. And so what Associate Justice Wood delved into was what we call the circular conundrum.
So explain that.
When looking at this, what Associate Justice Wood was, he looked at the case of Manieri and Cirillo, and I'm going to read a passage direct from the judgment. If the indemnity principle is considered at the time of taxation and the liability to the practitioner in an agreement is triggered by a favourable costs order, then the liability crystallises before the taxation. Where the liability is triggered by an amount recovered, there is no liability at the time of taxation. This is the circular conundrum. What comes first, the chicken or the egg? Is there a liability to pay costs prior to the taxation? If there is, then they're recoverable. If the liability crystallises upon the end of the taxation or upon recovery, then there's no liability to pay those costs prior to the taxation. They shouldn't be included in the bill and they're not recoverable.
Yes, it's quite a conundrum. So I think the lesson taken from that is never to have your cost agreement contingent on recovery of the costs themselves from the other side. Would you say that would be a fair piece of advice?
That's exactly right. But then what the court looked at is to whether there was liability for disbursements and counsel's fees. Now looking at counsel's cost agreements, so there were 3 in this matter, 2 for junior counsel and 1 for senior counsel. A clause in senior counsel's cost agreement stated that where there is an order for costs, that triggers the liability. So this was a conditional agreement. Counsel wasn't going to charge unless there was a favourable costs order. That clearly crystallises prior to a taxation, and so these fees were deemed to be recoverable. Junior counsel was a little bit different. In junior counsel's first cost agreement, she included a clause similar to the solicitor in that fees would only be charged upon recovery. However, later on in the proceeding, junior counsel changed her cost agreement, issued a new one that was retrospective, which contained a clause very similar to seniors, and so that liability was triggered upon a favourable costs order. And so what the costs court said was that because crystallisation happens prior to a taxation, both senior and junior counsel's fees were recoverable.
Interesting, isn't it? I think that's a side issue, whether you can actually backdate or retrospectively enter into a cost agreement, and it seems on evidence that it's something that is possible, that perhaps can rectify some of these problems. But fundamentally getting it right in the first place, certainly from these cases, we can see that there are some lessons to be learned. Perhaps you could just recap some of those.
Most definitely. I think the major things to come out of these two cases is that, firstly, if the other side, the solicitor for the unsuccessful litigant, asks for your cost agreements, there's decisions in the court which say they're entitled to review these documents prior to a party-party taxation. Then that leads to make sure your cost agreement's right. If you're going to work on a pro bono basis, make sure you have a clause that states we will charge you if you get a costs order in your favour, or if it's conditional, again, make sure that crystallisation happens before the conclusion of a taxation or before recovery of any monies from the unsuccessful litigant.
So it's how the entitlement to charge fees is crystallised. It's not about whether they should be crystallised or not, it's a question of when. They shouldn't be crystallising on the recovery of them, because effectively that becomes a circular conundrum. It should be crystallised either on the award by the court of an entitlement to costs, or some other act prior to the taxation or assessment process.
Exactly right, yes.
Great, well that's a really interesting discussion, Chris, and we'll probably see a lot more of these technical issues arising in relation to some cost disputes in the months and years ahead. There always seems to be one or two new angles with respect to recovery of those costs and the liability issue and the indemnity principle. And it's great to have explored some of these with you today, and I appreciate you coming along.
No worries. Thanks, Mike.